States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Good morning, everyone. We will hear 5 cases this morning, and we will probably take a break after the 3rd case, just for those who are coming a little later for planning purposes. We'll start with United States versus Andasola, number 19-1482. Counsel, you may proceed. I believe you'll get us started. Mr. Ross-Chabot.
Yes, Your Honor. Good morning. May it please the court, Jake Ross-Chabot on behalf of the appellant Jose Andasola. Mr. Andasola testified that a key piece of the government's evidence, the video footage showing him distributing packages of drugs to a criminal informant, was fabricated, which he knew because he had seen the original unedited version. The district court instructed the jury that the defendant's testimony was inaccurate, that as a matter of fact, the jury the video had seen was the only video. By introducing new evidence to the jury, the district court violated Rule 605. And because the district court's instruction completely eviscerated Mr. Andasola's credibility and his defense, the error was not harmless beyond a reasonable doubt. Rule 605 generally prohibits judicial testimony.
Counsel, could I just ask you to clarify one point? It seems from the government's brief that it discusses 2 alleged errors. One, the Rule 605 error that you're mentioning, and the other invading the province of the jury. Do you agree that there are 2 separate issues, or are those just 2 sides of the same coin?
I mean, I think they can be separate issues, and here they're just sort of inextricably intertwined. Because you can imagine a scenario where a judge invades the province of the jury by just instructing the jury that they had to accept a specific fact that was already in evidence, and then that wouldn't violate Rule 605 because the judge isn't the one introducing the evidence. Here, where the judge said you have to accept as fact this fact that I'm telling you, that invades the province of the jury and is a Rule 605 error. And so that's what we're raising here, that it's specifically a Rule 605 error. And that's important because Rule 605 specifically says that you don't have to object in order to preserve it. It's automatically preserved. And although the government doesn't concede that—
Counsel, the rule says that, but beyond the rule, didn't the defense counsel tell the judge that the judge could tell the jury that the video provided in discovery was the same as Exhibit 14?
He did, but that was well after the fact. It was after the judge had already announced its ruling. And so there was the functional equivalent of saying, it was after he'd announced his ruling and after he'd already overruled multiple objections. So it was a functional equivalent of saying no further objections.
Well, but in addition to that, didn't defense counsel also tell the judge that the instruction that the judge proposed to give was okay?
I don't think he said, not on top of, I don't think there are 2 separate places where he agrees to, he agreed that as a matter of fact, his opinion was that he didn't think that the videos were any different, but that his client should be able to testify what he believes to. I don't think there are, as far as I know, there's not a separate place in the transcript where he agrees to the instruction other than at the very end. So the government proposes that the judge should instruct the jury that there is in fact only one video. The judge then asks defense counsel if he agrees with that or if he has any objections. He then starts to say that Mr. Andasola believes, before he's cut off by the judge who says, I don't care what Mr. Andasola believes, he could believe that there's a flying spaghetti monster. What I'm asking you is, do you have any evidence that the fact that the government is proffering is untrue? In other words, do you have any evidence that there is in fact another video? And he said no. So the judge then announced, then I'm going to give that instruction. I'm going to give the government's instruction. However, if you have any objections, I might reconsider. So at that point, the judge has already made up his mind. Nothing that the defense says after this fact induces the judge into making this erroneous instruction. He then tries to make another objection, which the district court quickly overrules. And only after all of that does he say, well, then I guess you can instruct the jury that way. So he's not inducing the court to make this erroneous instruction. He didn't make a 605 objection and then withdraw it. He never acknowledged 605. And in fact, he doesn't have to raise any 605 objection in order to preserve it for appeal. So there's no inducement and there's no intentional relinquishment of a known right that would constitute a waiver. So
does he ever? Yeah, I didn't find where he, other than saying okay, I didn't find where he suggested that the judge could go ahead and instruct the jury, or that he was anywhere that he was actually agreeing with it, other than saying okay at one point.
It was just more than that. It's at the very end. He says, after everything that I've just gone through, the multiple objections, the judge's announcement that I'm going to do this unless you have a better objection, then I might reconsider. He overrules his other objection, and at the very end, he says,
he says okay.
Okay, right. I think you can tell the jury that.
Right. Okay, I think you can tell the jury that.
I'm not seeing that. Sorry about that. Yeah. All right.
So why doesn't that? I mean, why isn't that a form of a so-called super waiver, an invited error, which seems to me overcomes even a Rule 605 objection?
Well, there's no invited error because he didn't. Invited error requires inducement. It's this idea. It's based on reliance interests. The appellant can't, in the lower court, have asked the judge or told the judge or encouraged the judge, induced the judge to do one thing, and then on appeal say, aha, that judge made an error. It's like, well, no, you told him to make that error. You're the one who induced that error. That can't have happened here. There was no inducement because the judge had already made up his mind. He said, I am going to give the government's proposed jury instruction. However, if you have any further objection, I might reconsider. He didn't have another valid objection, or he had one more, which the government overruled before he finally acquiesced. So at that point—
Does acquiescence be consistent with a stipulation? We've held that stipulations to instructions are
sure,
they don't have to be jointly proposed. They can just stipulate that the instruction can go forward, essentially. Right,
and this court does, in the jury instruction context, if the government proposes an instruction, the defendant proposes an instruction, and then eventually the defendant agrees to some sort of compromise one, then this court has said, well, you ultimately agreed to that one. You withdrew your prior objection. But here there was no withdrawing of any of his prior objections. And again, he doesn't have to raise Rule 605 in the first place anyway. Here it was just the judge announced the ruling and said, do you have anything else? And so, it would really just be, they're not magic words saying, okay, you can do that. It's the question that very often does lead to inducement, but it just didn't here because the judge had already announced his rule.
Why? Okay, I understand your position on that, but the instruction was, there is only one video here. That was the instruction to the jury, correct?
Essentially, yes.
Let me ask you this hypothetically. When the parties stipulate to something, say they stipulate to a elements jury instruction, and because of that stipulation, the judge gives that instruction, is that the judge testifying?
No, Your Honor. There's certainly exceptions to the judge being able to sort of introduce evidence in a way. I mean, the judge can present the party stipulations to the court, to the jury, but that usually comes in the form of, a written stipulation that's given to the jury at the end of the trial, along with other instructions.
What if you have an oral stipulation in court that say it's an oral stipulation to a proffer from a witness who's not going to appear, and the judge gives that stipulation and states it like this: so and so, if they were to appear as a witness, would testify as follows. Period. Is that the judge testifying, or is that the judge,
Your Honor,
delivering what is an agreement between the parties?
Sure, the judge could do that. The judge can deliver stipulations of fact. The judge can also introduce evidence that's judicially noticeable. There certainly are exceptions. Not every time the judge tells the jury something, but here this isn't a stipulation of fact. At least in this court's pattern jury instructions, stipulations in criminal trials, the jury has to be told that they don't have to accept the party stipulations of fact. Here, that certainly didn't happen. The judge just told the jury a fact that was directly contradictory to what the defendant himself had testified.
But it was consistent with what his lawyer said.
His lawyer didn't have any evidence that was what the judge was instructing the jury was factually incorrect. That's true, but just because the defendant doesn't have any contrary evidence to a government's proffer doesn't mean that that the right to have the jury find those facts, that the defendant no longer has that right. The defendant still has a Sixth Amendment right to have the jury be the lie detector and the fact finder. And it's difficult to accept the fact that an attorney can at a sidebar stipulate to a fact that his client has just testified under oath is not true. The government hasn't argued that this was a stipulation of fact. So if that's really what was going to be the linchpin of this court's decision, then I might ask for some supplemental briefing on the issue. But I just can't imagine that a lawyer can stipulate to a fact that their own client just testified under oath was not true. It's the government's burden to prove that this was harmless beyond a reasonable doubt. As an initial matter, they don't actually take on the full extent of that burden in their answer brief.
Counsel, if there was error here, was it a constitutional error or a non-constitutional error?
So this court has held in Nickel that a violation of Rule 605 is reviewed for constitutional harmless error, harmless beyond a reasonable doubt. I think the invading the province of the jury is also grounded in the Constitution, because the defendant has a Sixth Amendment right to have the jury be the fact finder. And Rule 605, it makes sense to apply a reasonable doubt standard, a harmless error standard to that, because it really is constitutionally grounded. It's a due process violation to have the judge be the one testifying. You can't cross-examine a judge, so the right to confrontation is invoked. So it really is a constitutionally based error, and I think that's probably why Nichols said that it is reviewed for.
Is there any other authority you've encountered holding that a Rule 605 error is a constitutional error?
I don't think so, Your Honor. But Nichols expressly states that, and it is published 10th Circuit case law, so I think it is binding on this court absent en banc review. And I see that I'm running a little bit low on time and would like to save some time for rebuttal if there are no further questions from this court.
Thank you, counsel. We'll now hear from Mr. Grewell.
May it please the court, Bishop Grewell on behalf of the United States. First, just the waiver question. This is at pages 454 and 455 of Appendix 3. Ms. Rangel proposes that you say the video that defense counsel just referenced is the same one as Government Exhibit 14. There is no other video. Then page 455, the court says, then I agree with Ms. Rangel's proposal. That's what I'm going to do subject to your objection. If you have a good valid objection, I might reconsider. So the court had not already made its decision on what it was going to do. Mr. Bornstein then says, well, my objection is simply that I didn't bring Exhibit 14 to the jail. And the court says, but you've been told by the government that that video is Exhibit 14, at which point Mr. Bornstein says, the same? Okay, then if the government of course represents that the video given to me in discovery is the same as Exhibit 14, and I think you can tell the jury that. That seems to me to be an intentional relinquishment of a known right. He's saying, I think it's proper to do that now that I've got these facts in front of me. So I do believe it was a waiver.
That's not exactly what the court ultimately did tell the jury, is it? That the video that he received was the same. I think it was a little different than that.
Yeah, I believe what the court says is that, I think I have it right here, that the court says that that Exhibit 14 is the only exhibit, that there isn't another video, basically.
More than that. There's more than that. I've got the transcript here. Hold on. I think the court says something about that there's been some testimony that there might be another video and that you should not, that there isn't, essentially. He basically says you can't infer that, or the video is labeled. Yeah, there's, to the extent there was any implication that another video exists, that is not an accurate statement. So the court does more than what defense counsel agreed to, is my point.
That there was only one video, and I think it's what she's proposing on page 454. She says that the same one as Government's Exhibit 14, there is no other video. So that's what she was proposing, and then he says, I'm fine with that, and that's what the court does. But I want to turn now.
Wait a minute, not so fast.
Sure.
It is true that the judge also effectively said what has been stated in court by the only person as the defendant is not true. Isn't that so?
I think that can be an implication, but that implication was in the instruction she proposed. And so simply on the waiver point, I agree that might affect the harmlessness point.
How's that an implication? The court says, to the extent there was any implication that another video exists, that is not an accurate statement. What else would the court have been talking about?
Right, and what I'm saying is when she says there is no other video in her proposed instruction, that same implication is there in what she's proposing.
There's a difference between saying there's no other video and saying the defendant is lied, essentially, I think.
I don't think it's that the defendant lied. I guess the jury should have taken in the context of his numerous other statements that he was a drug addict and he had a ton of memory problems. And so I think the jury could simply take this as he was misremembering that part of the video. But given your concern,
so that is a comment on the credibility of the witness generally, right?
Which I think he's waived. But if the court disagrees, I think I should probably address the harmlessness of whether there's a comment on the witness's credibility can actually be harmless here.
Before you get that, do you think that a defense counsel can stipulate away the testimony of that lawyer's client?
I actually think, and not to help Mr. Rochebeau here, but I think there's at least an unpublished decision by this court suggesting that when a defendant doesn't agree with a factual stipulation, that defense counsel can't do that over his counsel's objection. As Mr. Rochebeau pointed out, however, this has not been presented as a factual stipulation. But I can certainly try to find that case and provide it to the court if it would be helpful. So I would agree, Your Honor, that a counsel cannot factually stipulate to something, at least in that case, if it's clear that the defendant himself doesn't want to factually stipulate to that point.
And you say that there's a concession on appeal, that's all irrelevant because this is not a factual stipulation?
They have not raised it as a factual stipulation. It's simply raised as an instruction or as a comment by the judge on the facts of the jury, what the jury could determine.
Well, and you're saying, to the extent they are saying it as a comment by the judge, on the facts, you're saying that it's okay for defense counsel to stipulate that away if you claim waiver, right?
If it's a factual stipulation, then they couldn't waive that. If that's how the court looks at it, then it could not be waived.
And that's what you're saying.
I would agree with that, Your Honor.
All right.
I want to turn now to the harmlessness, and I want to go directly to it as commentary. As let's assume that the jury had believed.
Counsel, before you get to harmlessness, if there is no waiver or invited error, are you conceding error?
We are conceding error, Your Honor, whether it's considered Rule 605 error. I think in Nickel, this court basically said a judge sort of taking a fact away from the jury like this is 605 error. The only point in our brief was it didn't seem like, no disrespect to Judge Murphy, but it didn't seem to us like that was the plain text. But I can understand why maybe that sort of error is going to get pushed in here. And so I do think, related to your earlier question, I think they probably are two sides of the same coin at least in this case. But we are conceding that there's error, and that's why we've spent our time arguing about harmlessness in the brief. Unless there are further questions on that, I would like to turn to the harmlessness inquiry. And I think the standard, and we are arguing harmlessness beyond a reasonable doubt. That is the standard from Nickel. We didn't put those magic words in our brief, but we did use the standard that Judge Murphy applied in that case to decide harmlessness beyond a reasonable doubt, which is whether or not the competent evidence was sufficiently strong to conclude the improper evidence, i.e. here the judge's comment, had no effect on the jury's decision, page 1294 of the Nickel decision. I think if you look at the evidence here, the reason that's the case is because even if the jury was going to believe the defendant here, his testimony was as inculpatory, if not more so, than exculpatory. He did make some conclusory statements about how he didn't distribute drugs and the like, but I would urge this court to look at several parts of his testimony. First, pages 416 and 417, which is where the prosecutor asked him, or where he's asked on direct, actually, if you were not arranging to sell heroin or methamphetamine, what were you doing? His answer, one day at night, we were together, a cousin of Armando's, and they had some packages with them, and they wanted me to keep them for them in my house. And I told them no. I told them bury them out on the street. Why would you bury these packages out on the street? Because he knows they're drugs. Then he goes on to say, and we were parked in our cars like this, and the next morning, he called and asked me to bring them out, but I didn't find it. Didn't find what? The packages that were hidden. Were those packages the drug packages? Yes, those are the packages that have been said to be drugs. I never even saw them. Then to page 418. Sorry, not 418, page 440. You're in the green Tahoe in this part of the video. Yes, I'm with Armando. If you watch the video, at no point does it show who's in that green Tahoe. He's indicating, yes, I was there, and I was there in this car with Armando. Page 448 and 449 then of the record. And going back to your conversation with him, you mentioned that there were no drugs at your property. Well, I didn't have anything, and I didn't even have them in my hands in the video. I didn't have them. I mean, I don't know if maybe they were out at the ranch. I don't know. Then he goes on, he's asked, okay, but you also told him that people delivered drugs to you to be distributed. No, we just bought little bits at a time for our own use. And people hear about that, and they come, and they give me a little bit. And when I have any, I give it to them. And then the next page, 449, you refused to tell law enforcement on November 6, 2017 who delivered drugs to you. Answer, nobody ever delivers drugs to me. It was just that one time with Charo and with Armando, but I don't remember when that was. That's what they wanted. I don't remember when. He's effectively admitting to the fact that he was distributing drugs in those different statements, that he was there at the time, that he was in the green Tahoe with Armando. And then at no point in his testimony does he challenge the numerous pieces of substantive evidence putting him there in his own admissions that are on audio and video. He doesn't challenge the phone calls before where the CI and he are setting up these meetings, talking about cars and cheese and horses. He doesn't challenge any other part of the video about the day the drug deal occurred, only the shot where you see the hands. He says, I saw one where you don't see the face of the person. That's all he challenges. He doesn't say he wasn't there, that he didn't have these conversations, that this whole other stuff went on. The numerous times in that video, he's talking about how much meth the CI wanted and encouraging him to take 2. On that tape, he never questions the CI when the CI is referencing crystal, meth, or the black. He doesn't act confused as to why they're meeting. When the CI asked Andasola how much crystal he has with him, he says 2. And then when the CI refers to the crystal as meth, he isn't saying, no, I'm talking about chandeliers. He says that one is clean. And then numerous times before the drugs are passed off, he said he's repeatedly asking if the CI wants 2, and it's 2 pounds of drugs, 2 pounds of meth that are found in the car. The officers had searched the car before it went off. You have continuous video throughout showing this. There's no break in the video that's shown. And then now all of a sudden we have drugs afterwards. And he doesn't challenge the audio and video of the February 23rd meeting with the DEA agent who wasn't running this investigation. He was just simply brought in because he spoke Spanish. So he's brought in for this one segment. And they meet, and Andasola is on there, and he isn't confused about the quantities of drugs that are being talked about. He's the one asking the agent if he wants crystal and saying he'll throw in the good stuff white, i.e. cocaine. He's the one talking prices on kilos and saying that's what the powder is going for. He's the one talking.
But you're talking now about a transaction for which he was not indicted.
Well, this is where he goes and collects the money from that transaction, and then he's starting to do another drug deal.
Right, but it's the other drug deal that is the subject of the indictment, right?
Certainly, but I think both the fact that he's collecting money from the one that's charged, and then he's arranging another one is evidence that showing again whether it's part of the sufficient evidence showing that this error here didn't affect anything, because the jury's going to say, okay, you collected here, you're collecting the money here, discussing drugs again. Well, what is it you're collecting money for? Yes, the fact that you did a drug deal earlier.
Now,
and when they're talking about,
you use the word sufficient evidence. That's not the approach we take, is it? We don't.
No, sorry, that's misspeaking. That the other evidence is sufficiently strong to determine that this comment didn't affect the jury's verdict. And so, basically, the fact that he's not challenging any of his own incriminating statements, his own words before the deal, his own incriminating statements on the day of the deal, and his own incriminating statements when he's collecting the money, combined with the fact that the drugs are then found, and all of his testimony that further inculpated him, saying, yeah, go bury it in the street. Yeah, it was Armando came over. Yeah, that's me and Armando in the car. Well, no, I didn't. Drugs weren't delivered to me. Well, that one time with Armando and Charo. Yeah, well, no, I didn't distribute drugs. We just got some for ourselves. Well, and yeah, sometimes I'd give them to other people. All of that evidence combined with all of the physical, audio, video, and drug evidence that he didn't challenge here meant that the nickel standard, that the competent evidence was sufficiently strong to conclude the judge's comment had no effect on the decision, was met here. And we would ask this court to find that the error, if it wasn't waived, was harmless beyond a reasonable doubt. Happy to answer any other questions the court might have or cede the remainder of my time.
Thank you, counsel.
Thank you.
Mr. Rochebeau, you have some rebuttal time.
Thank you, Your Honor. I just want to emphasize what the harmlessness beyond a reasonable doubt standard isn't and what it is. It's not whether this court would find him guilty beyond a reasonable doubt, or whether even a hypothetical reasonable jury would find him guilty beyond a reasonable doubt in a hypothetical trial where this erroneous instruction wasn't given. It was whether the verdict actually rendered in this case was beyond a reasonable doubt unattributed to the error. And it's impossible to say that it is here, where this was clearly such a big moment in the trial where the district court instructs the jury that the defendant had essentially lied under oath, and that his accusation that the government had fabricated evidence was simply not true. It completely undermined his credibility and his entire defense. And I just don't think that this court could confidently say beyond a reasonable doubt that the actual verdict was not attributable to the error.
Well, it just seems like so much of the tape, independent of this controversy over a little part of it, that the defendant raised, is vast and establishes perhaps guilt beyond a reasonable doubt. independent of the portion of the tape that may be contested by the defendant. Isn't that the way we look at it?
No, Your Honor, and I would grant you that there is sufficient evidence to find him guilty beyond a reasonable doubt, and as you pointed out, that's definitely not the standard here. The question, I see that amount of time, but if I could just give a...
Let's continue this conversation.
Please.
Thank you, Your Honor. It's not whether there's sufficient evidence or whether, that this court would find him guilty beyond a reasonable doubt. There's certainly plenty of evidence in the record that went unrebutted by his testimony. But he still had a constitutional right to have the jury decide to have the jury assess his credibility independently. It may not be the most compelling defense.
But his credibility that's to be judged is his credibility on the witness stand. But isn't that entirely separate than his credibility on the tape, the portion of the tape that's uncontested? And if you look at that, doesn't that suggest that the error of the statement by the district court was harmless beyond a reasonable doubt because it only reflects a little bitty portion of the tape, where the vast amount of the tape, he doesn't contest. So that's what happened.
Right, Your Honor. I think that narrowly focusing on the small portion of the tape that was disputed it is too narrow of a focus, because if whether or not that's him is not necessarily the heart of the case, but what would become the heart of the case and the heart of the defense is if even one juror credited his allegation that the government in this case, that the officers in this case had manufactured evidence. If the jury credited that allegation that this evidence was just a deep fake video, then the government's case can crumble like a house of cards. At that point, what other evidence is fabricated? It certainly wouldn't be the first time that the law enforcement planted evidence, and it wouldn't be the first time that a jury acquitted based on those types of allegations.
Would you concede that the approach you just stated at least borders a per se prejudicial error under 605? That 605 is really a per se rule?
I wouldn't say that it is a per se rule. I mean, I think in this case, it is so extreme that it sort of is like a structural error adjacent, in that what the judge's instruction went directly to the defendant's credibility. He basically called him out as lying on the stand. And it was just so central. It's hard to measure the impact of that, or hard to say that such an egregious error is completely harmless. I can imagine much more very obviously harmless Rule 605 violations. For example, if the judge was just correcting the testimony of an agent who, let's say, from a suppression motion, for suppression hearing, a judge knows that the car was red, not blue, but it's just a minor detail. The cop testifies that the car was red at trial, and the judge interjects and says, actually, the car was blue. Obviously, that has nothing to do with the jury's verdict. Then you could say that, that is surely unattributable to the jury's verdict in this case. But in this case, where he essentially told the jury, instructed the jury that they couldn't believe him, it's hard to say that there would be a time where that is harmless. Thank you, Your Honors. I'm well over time. Thank you, and I ask you to vacate his conviction.
Thank you, counsel. The case will be submitted. Mr. Rochebeau, you may be excused. Mr. Gruelle, you're on the next case, so you're not excused yet. All right. We'll now hear United States versus Velarde, number 20-1115. Mr. Scabavia, you may proceed.
Thank you, Your Honor, and may it please the court. Mark Scabavio on behalf of Alvaro Pablo Velarde. This case has many issues. I want to start with the issue of Cadet Carlos Hinojosa. I wanted to use Cadet Hinojosa as a trial witness. And I wanted to use him because he was the roommate of Velarde. He was the very first person that Velarde talked to after the incident, which was only 6 hours after the incident. And it was the only person that Velarde talked to before any suspicion anything was wrong. Hinojosa also brought to the table that he saw and observed a romantic relationship between the victim and Velarde before the incident, and the day before the incident, they were actually kissing in his room. So I thought that would be very important testimony for the trial. But I could not use Hinojosa, and the reason why I could not use him is because Hinojosa said Velarde told him the victim said no 3 times during the incident. Not only did he tell me that on 2 separate pretrial interviews, but he also told OSI that appeared in a news article during the trial, and it appeared in court documents. So what could be more damaging in a rape case than when the victim tells the defendant no? In our society, it's well known that no means no. That would be severely damaging to my case. So I could not call him as a witness. But after trial, post-trial, right before sentencing, Cadet Hinojosa calls up Velarde on a BTC and recants all these no statements that he said. And he said that, and then because of this, I went ahead and interviewed him again post-trial. And so now all this information, all this trial testimony that I could have used, that I couldn't use before, I could have used now. So I argue that is, for purposes of new evidence, is new evidence because I could not in any way use it at all.
Counsel, as to these post-trial statements that you'd like to use, the motion for new trial didn't present any of those statements in the form of recordings or transcripts or affidavits. Why isn't the record insufficient for that reason alone on this issue?
Your Honor, I believe that the motion for new trial, which is in the record, contains the transcript of that BTC conversation between Velarde and Hinojosa. It was translated.
No. I'm talking about the post-trial recantations.
The post-trial recantations. One of the recantations was that BTC conversation. Besides that, it was to me, and I believe I summarized what he said to me in my motion for new trial. In my motion for new trial. But after I talked to Hinojosa and after he came clean with me, he gave me more information that I never knew before as well. One of these things is that the victim told many people about the incident afterwards, which I never knew about. That the victim post-trial hid Exhibit A. Exhibit A, of course, is the victim as a text message conversation between the victim and Velarde saying, or not victim, but the victim and one of her friends saying how she's attracted to Velarde, how she doesn't want him to talk about it or anything. And I found out from Hinojosa after trial, she was hiding that from him, even though her and Hinojosa were really good friends. He found out that she was hiding it from him the whole time. And then most importantly, though, what I get from Hinojosa is I get pointed in the direction of Cadet Lillian Landis, who I never talked to pre-trial, even though I talked to more than 30 cadets at the Air Force Academy over several months. I never heard of a Cadet Lillian Landis, but he pointed me in a direction post-trial, and she has, which I'll explain a little bit later, a lot more to say.
Counsel, could we just isolate what statements post-trial were actually new evidence? I mean, as I understand it, one of them is he denied telling Mr. Velarde that the victim that Mr. Velarde told him that the victim said no, and then he also said he no longer believed that Mr. Velarde was guilty. Those seem to be the new evidence statements, but isn't that it? Those are the only new evidence statements.
Your Honor. Besides that, the fact that that the victim hid trial exhibit A from Hinojosa, that she actually hid that text message conversation from him.
That's new evidence?
Yes, Your Honor, that was. I never knew that. He told me post-trial that after the trial occurred, she hid those conversations from him. Even though they happened in the trial, he knows he wasn't there watching the trial because he was a potential witness. He was sequestered, but he never knew about those conversations until way later, and she hid it from him for months after the trial. And if that answers the question, Your Honor, I want to talk about Hinojos' credibility because the district court said that he was not credible because of a conviction of his friend and a falling out with a victim. It says the district court just says that as the reason only, but there are lots of reasons to believe that he's actually very credible. First is the fact that he actually recanted on his own without anybody telling him to do so or asking him to do so. He did so. It was a surprise to everybody, and everybody was surprised that he recanted. But what's more important, and we also found out that the reason why he was lying beforehand was because OSI was intimidating him like he intimidated other witnesses in the trial, which is on the trial record. Cadets Lobiano and Pierce were both intimidated by OSI, where the OSI tried to put words in their mouth saying, "We don't believe you, you're going to get in trouble," using the honor code against them. But I think there's no question that the honor code is a huge deal at the Air Force Academy. All my witnesses, all 6 of them, and the victim, all testified that if they violate the cadet honor code, that they will be subject to expulsion, and that's just lying. So by coming to me, and by coming clean to Velarde and coming to me and recanting everything he's saying, he's doing so at the expense of possibly being kicked out of the academy for lying and losing his entire Air Force career. And I cannot think of anything that would make somebody more credible than that if they're going to go ahead and go back on what they said, talking to official parties like me, saying that they were lying. So I think it makes them extremely credible. Turning now to Cadet Landis, because in order to understand why Cadet Landis was so important, a person I never knew about beforehand, Cadet Landis is important because right after the incident, victim told many people about the incident. She never mentioned anything about ever being hit in the back of the head by Velarde. And even when she saw the doctor 7 days later, she said she hit her head on the bedpost of the bed. It wasn't until OSI talked to her 14 days later on their second interview that she said Velarde hit her in the back of the head. And then she maintains that throughout the rest of the time, through trial, through her testimony, that the reason why she got a concussion was because Velarde hit her in the back of the head. Well, I talked to Cadet Landis now post-trial, and I find out that right after the incident, Cadet Landis and victim became acquaintances or confidants, where victim would talk to Landis once a week for a period of 6 months up to trial. In fact, she confided in Landis so much that they made Landis her roommate during trial in Denver. And when I talked to Landis and I asked her about it, Landis told me that she consistently told her that she got the concussion from hitting her head on the bedpost, not being hit in the back of the head by Velarde. This was her confidence through the entire trial. So why she's testifying in trial, saying that she was hit in the back of the head by Velarde, she's telling her confidant the whole time that she hit her bedpost. This is a huge, huge inconsistency.
When did Miss Landis become her roommate?
I'll clarify that, Your Honor. She was never her roommate in the Air Force Academy, but when the Air Force Academy did the trial, when the Air went down to the trial, all the cadets went down for the trial, they put Cadet Landis and the victim as roommates together in Denver during the trial. That was when they were roommates. That was only when they were roommates. But
Landis never testified at trial.
No, Your Honor, she did not. And I never knew about her at all throughout my entire time.
Didn't know anything about her. She
Nothing.
was never identified as a witness.
Not by anybody, not by any cadet, not by any of the 30 cadets I interviewed or officers or anything. Nobody ever pointed me in Landis's direction. But she directly contradicts the victim in a dramatic fashion. And not only does she impeach the victim dramatically, but she also corroborates Velarde's story that he never hit her in the back of the head. And I believe that is a huge deal. And that's why if I had knew that beforehand, Landis would probably have been my first witness in trial, impeaching the victim and then subsequently corroborating Velarde's account of the events.
Were there other witnesses who testified about whether she said she got hit in the back of the head or hit her head on the bed rail, one versus the other? Weren't there other witnesses who kind of testified contrary to her about that?
There were, but it wasn't as dramatic. It wasn't as clear.
What? Explain.
for example, a lot of my witnesses said that Velarde told them that it was more like an absence of saying it. Like all my witnesses, none of them said Velarde said that he hit her in the back of the head. None of I don't know if any, I can't remember off the top of my head if any of the government's witnesses said that she said he hit him in the back of the head. I believe at least two of them said that. I believe two of the government witnesses said that victim told them that Velarde hit her in the back of the head.
And did anybody say that victim told them that she hit her head on the bedpost? Was there any other testimony about that?
No, Your Honor.
Other than?
No, Your Honor. Other than no, there was none. There was none. It was the only time it came out that she hit her head on the bedpost was when she initially told it to OSI, but she never told any of the witnesses. None of the witnesses said that. It was only Landis that said that afterwards.
This would have went to the victim's credibility then, right?
Yes, Your Honor, and also to the
teacher. Impeach her.
Impeach her, yes, Your Honor, and corroborates corroborates the defendant's account.
Okay.
Moving on, because there's a lot of other things here, but I also wanted to talk about the next most important thing, which is Dr. Jackson's statements, which were misstatements of what his qualifications were by the Assistant United States Attorney during rebuttal argument. Those statements were that Dr. Jackson is one of the preeminent concussion doctors in the United States. Dr. Jackson is the principal researcher of one of the biggest concussion studies to have ever been conducted, and that Dr. Jackson is the leading concussion expert. So we have somebody that literally had a concussion, but she sees somebody for a concussion 16 times over 5 months for a concussion, which is just not, people just don't do that, Your Honors. People don't see a concussion doctor 16 times over 5 months for a concussion in any normal sense. And
was there an objection to that?
No, Your Honor. That's why this is for plain air review.
Was there an instruction to the jury that what counsel says is not evidence?
I believe there was an instruction that off the top of my head. I think there was, Your Honor.
Combine the requirements of plain air with that instruction. Doesn't that indicate that the plain air standard is not met?
I don't think so in this case, Your Honor, because it's such a close case. I think that's what takes the balance of that one, because this case was so close for many reasons. But you have these statements, and then you have this extreme amount of times you're seeing a doctor for a concussion, and then because of these overly broad or these overly stated qualifications, such an unbelievable story of 16 times over 5 months for being hit in the back of the head, it makes the unbelievable become believable in the eyes of the jury.
Unless you follow the instruction that the judge gives you, and that is the evidence is what you hear from the mouths of witnesses, not from the mouths of the lawyers.
Yes, Your Honor, but then also the qualification of Dr. Jackson, which his qualifications were, was simply as a concussion doctor. That's all he was qualified as in front of the jury.
Thank you.
Counsel, could I ask you about the PTSD diagnosis?
Yes, Your Honor.
Could you explain how that is relevant and material to the defense?
Yes, Your Honor. Okay, so the PTSD was something that I never knew about until I talked to Dr. Jackson after the trial when he mentioned PTSD. Now they say they've given me diagnoses and stuff about having nightmares, flashbacks, episodes and panic and stuff, which could I guess be mental health problems. But my point is, I believe that she had PTSD not from the incident at all, but she had PTSD and was diagnosed with it before the incident even happened. And I think there is a mental health file over there in the Air Force Academy that has a PTSD diagnosis that has not been given to me. And that
I'm asking how that helps you. What difference does this make?
What difference? Because it gives a whole new reason why she would fabricate. Because she's more sensitive. She's had previous because it has a whole new theory of why she would fabricate the story. That's the answer to that.
And this is based on your opinion, or?
Yes, Your Honor. Well, I mean,
Did you have any evidence that would, did you offer anything that would show that if this was the case, that she previously had PTSD, that she'd be more inclined to fabricate in this instance?
Well, Your Honor, I never knew she had any PTSD or anything. I never knew about the PTSD diagnosis or anything or any possibility of it until after trial. And so if had I knew about it before trial, if I knew she was diagnosed with PTSD before trial, then I would have hired an expert to explain to the jury how that could affect her veracity in this case, or her reason to make up the story.
Thank you, counsel. I think we've gone over time a bit, and we'll now hear from Mr. Gruelle.
May it please the court, Bishop Gruelle on behalf of the United States. I guess I'll start with the closing argument allegation of error first. This is reviewed for plain error, and we have conceded that the third statement, the first two we believe are properly supported in the evidence. The third one I think was a bit of an embellishment, a little bit of an exaggeration in rebuttal close in terms of when he says that it's the leading concussion expert who runs the largest study. But as this court said in Lopez Medina, which is cited in our brief, 596 F3rd at 740, quote, a stray improper comment in closing is no basis for upsetting a trial, end quote. And then it goes on to say, this is especially true, whereas here the jury is advised that arguments of counsel are not evidence. That happened here, appendix page 705, right after closing arguments are over, the judge instructs the jury, the arguments of counsel are not evidence, you're to decide guilt and innocence based on the evidence. Moreover, this was not a case of competing experts. While counsel may feel that seeing somebody 16 times for a concussion is not what you do, there was no other expert who came on and testified about that. There was no testimony about that whatsoever. The expert here basically went uncontradicted, and so whether he was simply an expert or the leading expert really didn't matter here. Moreover, when we're talking about prong 3, the defense relied on the concussion expert to help them as much as the government did. In their closing arguments, at pages 676 to 677, they're relying on what our expert said, and they brought out testimony from our expert that her concussion could have been caused by a judo injury a couple days before the sexual assault here. So there's certainly not plain error here or anything worth reversing on the closing argument point. Unless the court wants to hear any more about that, I'm going to turn to the new trial evidence. Let me start, I guess, with what counsel says is their best evidence, I guess, the Cadet Landis testimony, and in particular, the statement that the victim told her that she got the concussion from hitting her head on the bedpost. Judge Moritz, to your earlier question, it's not actually true that nobody at trial said that she'd said a bedpost caused it. In fact, the concussion expert said that when he was treating her, she told him she got the concussion from hitting her head on the bed. So at most, this was going to be cumulative evidence. Moreover, the jury heard that she hadn't recalled about what had exactly caused her to lose consciousness until several weeks later. And finally, Mr. Velarde hitting her or her hitting the bed are not mutually exclusive things in terms of causing the concussion, any more than a linebacker hitting a quarterback or the quarterback hitting the turf is necessarily the cause of the concussion. It's not inconsistent to say he hit her and she hit the bed frame and that caused the concussion. In any event, that evidence, because it had already been presented by our witness, the concussion expert, was cumulative and wasn't probably going to lead to an acquittal, which is the standard for new trial evidence. The only other new evidence from Cadet Landis is, again, that IC tried to convince her that Mr. Velarde was guilty. That's no more consistent with innocence than it is with guilt. It wouldn't have probably led to an acquittal either. The PTSD evidence. I would direct this court to Appendix 129 through 132. That's where the district court here went through a litany of the things in the discovery that, if they didn't talk about it being PTSD itself, at the very least should have put counsel on notice that they had to do some due diligence here to see about the PTSD. But even if they had done that diligence and it came out, it's their burden and they've offered nothing to suggest what the cause of that PTSD is. Here, that PTSD evidence could be as damning as it could be exculpatory, that the PTSD could just as easily have been caused and probably was caused by the sexual assault here. So that wasn't going to help them. Let's turn to Cadet Hinojosa. And I think they allege 5 different pieces of new evidence. One of them is that Mr. Hinojosa no longer thought Mr. Velarde was guilty. Well, that's simply inadmissible. It couldn't have changed the trial here. You can't call witnesses to testify whether a defendant is guilty or innocent. Their opinion on that is inadmissible. That's a question for the jury. IC's motive to lie because of the cadet honor code. Well, first of all, that's just impeaching. But secondly, as counsel himself pointed out, he had 6 cadets come on and testify about the cadet honor code. Mr. Hinojosa being a 7th saying the exact same thing wasn't going to be something that was going to change the trial here. Moreover, the only way it's a motive for her to lie is if she lied in her initial statement. But the cadet honor code itself created an incentive for her not to lie initially. And so that wasn't going to help him in terms of probably leading to an acquittal. The hidden texts from Mr. Hinojosa, these were cumulative. Pages 215 to 250 and 250 to 251, you hear about how she actually hid texts from the investigators themselves. And so and she explained why she did that, and that she was worried at first, but then she goes and gets those texts that she had deleted from her friend who testified at trial, and brought those hidden texts to the attention of the investigators. So again, that was cumulative that she'd hidden the text. The fact that she'd also hidden them from Mr. Velarde's best friend and college roommate, Mr. Hinojosa, was not probably going to lead to an acquittal. Finally, we have 2 last pieces. He said that she told so many people about it. Well, that's no different than her telling Cadet Landis. I guess the theory is somehow that if it was a fake rape, she would have told everybody about it. But if it's a real rape, she wouldn't tell anybody. I don't think there's anything to support that. It's as inculpatory as it is exculpatory. And last but not least, he offers the recanted statement about whether she said no. He says he couldn't have called her. That's not actually true. What he didn't want to call, or he says he couldn't have called Hinojosa. That's not true. He didn't want to call him because, as he notes, Mr. Hinojosa had told the investigators that Velarde told him she said no 3 times. So the jury never hears about that. They never hear about that because he's not called to trial. After trial, Mr. Hinojosa says, well, no, that's not what he said. He said that she told him 3 times. It's not correct. Well, if you bring that to a jury, that's not going to lead to an acquittal either. First of all, let's just assume that the jury hears Mr. Hinojosa get up there and say, yeah, well, she told him 3 times. It's not correct. That doesn't suggest consent here. But that isn't all that a jury would have heard. They would have also heard his prior inconsistent statements where he said, well, actually, Velarde told me she said no 3 times. In his reply brief, he does suggest that somehow that Mr. Hinojosa somehow was going to say, well, Velarde actually told me she never said no. There's nowhere in their motion for new trial below that is what's suggested. It's only that he was recanting this statement that she, in fact, affirmatively told Velarde no 3 times. It wasn't that there was any commentary about whether she said no or not. And obviously, the district court here can only make a ruling based on what they're offering below. That wasn't offered. It was waived to the extent they're trying to say Velarde said she never said no. The final point on the new trial evidence, and then I guess I'll turn to the exclusion of the mother's testimony. This court has said several times that these are not favorably regarded and they should only be regarded with great caution. And it's also said because the district court is the one who has heard all the trial testimony and seen all the evidence, that it owes great deference to that 5th prong about whether or not this would probably lead to an acquittal or not. District court found it wouldn't here. And we're not talking about a plain error standard where it's a reasonable probability of a different result. We're talking about a legitimate jury verdict that can now only be overturned if it's more probable than not that the jury would have acquitted based on his new evidence. He hasn't met that burden here.
On the recanted no, isn't the primary problem that it's impeaching?
So I think that's a problem with much of the evidence. I think it's impeachment. I think, there are times when evidence can be both substantive and impeaching. And I suppose to the extent it's going here to the actual element of whether she consented or not, I could see it possibly being considered substantive as well.
Well, it's a little different. It's not substantive. It's just saying, I didn't say that before.
Right.
And so it's not substantive It's just It's just talking about what this guy said before and what he says now.
Right, and I guess it would just be the evidence of him saying that he said it's not correct 3 times. To the extent it's substantive, I think it's substantive evidence of his guilt, not his innocence. But it would just be, you know, if Velarde in fact told Hinojosa it's not correct 3 times, or said she said no 3 times, either one of those would be more evidence of his guilt substantially, but otherwise would just, as you point out, Your Honor, be impeachment.
All right, thank you.
Unless there are questions about the new trial evidence, I guess I'll move to the Rule 401 and 403 exclusion of the mother's testimony about whether the victim laughed when she got off the stand. First of all, I'd point out, I think the court is correct here when it's excluded under 401, because there simply wasn't the context to know what that laughter meant. There was nothing to suggest that it was more incriminatory than exculpatory, because we didn't know what conversation was going on. We don't even know when and where exactly it happens. He says it's immediately after she got off the stand, but throughout his reply brief and what he said below is it's when she's leaving the courthouse. Well, the courthouse is a big place. You got to go down in an elevator, and none of that's inconsistent with what the government put forth, that this came after she finished filling out her administrative paperwork and after she and her friends were getting together to go decide where they want to get lunch. When they're walking out the courthouse, none of that suggests that that's incorrect. Perhaps in a situation where the evidence offered is the second she leaves the stand and that door closes behind her, she bursts out into laughter, maybe that would have some probative value, but they didn't offer that. They didn't offer evidence suggesting that. Furthermore, there was a Rule 403 ruling here that was also correct. And that's because the district court recognized that we were going to have now a mini side trial on a collateral issue that was going to delay the case and was going to risk confusing the jurors. The jurors had been told you're supposed to listen to what happens in this courtroom, not be looking at your own observations. Well, now if they're going to hear a witness get on and say, I saw this in the hallway, the jurors might be at risk of thinking they can look at what they saw in the hallway to decide such cases. Moreover, we're going to have to bring in not just Velarde's mother, who was under a sequestration order, but now the friends who were with the victim when she was laughing, so that they can provide context to the story. And there's no evidence that they weren't in the courtroom either, so that would also be a violation of the sequestration order. And so, and all of this for very minimal probative value, because we don't know why she's laughing. We don't know what the basis for this is. And again, it's an incident, 6 months after the rape. There's nothing suggesting that there is any improper way for somebody who's been raped to respond to that. And so this was simply going to be unfair prejudice. The court was right to exclude it, and we would ask that this court affirm. I'm happy to answer any other questions the court might have about this case.
I just had one on your last point. Could you explain a little bit more what your argument is on sequestration? I'm not sure I was following that in your brief.
Sure, Your Honor. So I think the reason we tend to have sequestration orders for witnesses is because we don't want them observing testimony, tailoring their own testimony based on what's happening in court, or even making up stuff based on what's happened in court. And so we say we're not going to allow those witnesses in. The only reason she's even suggesting that this laughter, that the laughter sticks out to her, is because she's in court and she said she saw the victim crying on the stand and the like. So she's now creating testimony that would never have come forward, but for the fact that she's in that courtroom. And that's what sequestration is supposed to prevent, is people sitting there and coming up with things that they want to say now after having watched other witnesses go, or tailing their testimony to try and shape the trial in that way.
Thank you. Any further questions?
All right, thank you, Your Honors. I'm happy to cede the remainder of my time.
Thank you, counsel. Thanks to both counsel for your arguments this morning. The case will be submitted and counsel are excused. Our next case is United States versus Wells, 20-1228. Counsel, you may proceed. Mr. G.
Thank you, Your Honor. Good morning. May it please the court. We're here today. I want to focus on the interpretation of two statutes, Section 2241A1 and 113A1. First, with regard to 224A1, the question that we've presented is whether the district court properly instructed the jury on the elements. And specifically, as we pointed out, we published the jury instruction number 12 in our opening brief. The court omitted a mens rea from one of the elements of 2248.1, specifically the one relating to the use of force to cause a victim to submit to sexual assault. We think that was an error. It was plain error, and it substantially affected the substantial rights of Mr. Wells.
Well,
And-
counsel,
Yes.
wasn't that instruction stipulated to?
It was not. And more specifically, we don't have any evidence that was submitted beyond the statement in a filing in the district court. There was no, there's no transcript of any stipulation to that instruction. And the filing itself, the submission of instruction number 12 was not signed by Mr. Wells' counsel or by Mr. Wells.
Well, are you suggesting then that the government misrepresented to the court when it told the court that the parties had stipulated to 16 of the proposed instructions?
No, Judge Matheson, I wouldn't do that. I only point out that there's no signature on that stipulation by Mr. Wells' counsel, and the case law requires that before there can be a waiver of rights, there has to be an intentional relinquishment of that right, and the record does not support such a finding by this court.
Let me just follow up with one more question about this. When the government submitted the proposed instructions, they included a proposed non-stipulated instruction. Why doesn't that indicate that the defense stipulated to the other instructions?
Well, we for sure, we have the representation from the government in that submission that instruction number 12, what ultimately became number 12, was stipulated. My point is simply that either from the absence of Mr. Wells' lawyer's signature on that motion, on that submission, and the inference that Judge Matheson, you're drawing from the non-stipulated instruction.
Well, no, wait, I'm not drawing any inference yet. I'm just asking you a question.
Sure. I don't believe that the submission of a non-stipulated instructions suggests that there is a waiver as to, or that there is a stipulation as to the others, or more importantly, that the record would support that intentional relinquishment. And as we pointed out in our papers, Judge Matheson, even if it were stipulated, what became instruction number 12, the actual instruction number 12 is different from what was submitted by the government in the papers you've referenced.
It's not different in any sense that's material to your argument here.
Well, I don't know if that's true.
Well, explain to me how it is different.
Sure.
That relates to your argument that you're now making.
Well, the argument that we're making has to do with whether or not. Are you referring to whether or not knowledge was?
Right. Yes.
Yes, that's true. With regard to both the instruction that was submitted by the government and with regard to the actual instruction number 12, that's correct. Knowledge was not required as to use of force.
All right. What is the material difference between what was in the stipulation and what was given?
Well, Judge Kelly or Judge Murphy, we did point this out in our papers, but among the differences is how intent was referenced and whether the jury was required to or was given permission to make a finding. Must versus may, and intent versus specific intent, as two examples. And I don't know, Judge Murphy, if you have a quizzical look on your face.
I do, because I'm looking at the instructions that's given, and the answer doesn't make sense to me. I mean, I'm not saying that's your fault.
If I might, I'd like to come back to that during the rebuttal, and I don't have
that is perfectly fine.
Okay, I don't have the page reference in mind, but I actually identified these in the reply brief. The differences between the offered instruction.
Just go ahead, take care of it in rebuttal.
Okay, sure. So with regard to this question about whether knowingly should also be an element of the use of force, we cited a number of cases, and we think these cases are dispositive of both the plain error and of the harm from the absence of that mens rea requirement. And all of these are Supreme Court cases. Of course, there are many 10th Circuit cases that follow them, but they are Flores-Figueroa, there is Excitement Video, there is Rehife, and there is Liparoda. These are not decades-old Supreme Court cases. I mean, Rehife, I think, was 2019. So these are all recent cases that actually require that when knowingly precedes an essential element, that mens rea must be applied to each one of these elements. And I appreciate the government's attempt to distinguish these cases, but the distinction is not effective, because in every one of these Supreme Court cases, there is no exception to this general rule. Now,
Mr. G, assuming that we agree with you on that point, didn't the evidence nonetheless show that Mr. Wells knowingly used force?
Well, so here's I think we have to return to the plain error standard, and this court has repeatedly said that when the error is of constitutional dimension, we relax the plain error rule. Now, let me turn to the facts that are implicated by your question, Judge Matheson. There is substantial evidence of force being used during the course of this assault. The point that we made is that in count one, the 2241 count, is charging Mr. Wells with digital penetration. If you look at the record, volume 8, let's see, 75 and 76, it talks about that's where the victim is testifying about the actual force that was used. If you look at what she says with regard to digital penetration, this is occurring after she has testified about a series of series of physical acts used against her. Then the government asks the question, at some point, meaning it's not clear from the testimony, but the question is, at some point, did he remove your stockings? And she says, yes. And then comes the testimony about first an attempt to use kind of a wooden fork or something like that. And then comes an attempt to use the fork to do penetration. And then comes the digital penetration testimony. When we look at that testimony about digital penetration, there is not use of force. Now, the government in its answer brief expands what when the force is used. So as I read the government's brief, it's saying that force was used throughout the entire episode. But our contention is that that's not what the government charged. Count 1 charges force with respect to digital penetration. And this court must turn to those pages of the transcript that talk about digital penetration. With regard to section 113A1, I wanted to point out that, yes.
Don't we have to look beyond that immediate part of the transcripts? Because force applied before a specific act is still relevant as to the specific act, even though force may not have occurred right at that very moment. I mean,
yes.
There could. I mean, I didn't voluntarily take my stockings off. I did it because of the force that was being applied. And then comes the digital penetration testimony. Why isn't that the proper way to look at it?
Well, okay, so this temporal aspect of force, I think, has to be cabined in some way. I think we have some help here from the statute and from the case law, which talks about how the force that is relevant is the causative force. So, for example, something that happened 2 minutes before but was not relevant to the causation is not part of the analysis. That's what I would suggest to you, to Your Honor. And with regard to section 113A1, the question is whether that intent mens rea applies to all of the elements of 2241. I think that 3 cases, two cases I think are key to deciding that question. One is the Rehive case. And Rehive does not involve 2241, but it does involve I would say an analogous situation regarding the felon in possession statute. There you have 922G, and then you have the question of whether knowingly applies in the punishment section, penalty section, whether knowingly applies to both kinds of conduct, the firearms possession by that particular defendant and his status as a felon. The answer was yes, and the presumption that was applied in Rehive is that the mens rea applies to all the elements, even when they are in different statutes. So that's one point. The second point is the court decided a case in 2018. Judge Timkovich decided United States versus Curry. In the United States versus Curry, it was a 113A1 case, and the question was in the context of murder, assault with intent to commit murder. And in that case, Judge Timkovich held that to prove assault with intent to commit murder, the government must establish the intent required for, quote, a completed murder offense, close quote. That suggests, in that case, that the court is applying that mental state to every element of the predicate or of the related offense. In that case, it was murder. In our case, it is 2241. And we also can apply
counsel.
Yes.
We're winding down here. We've only talked about your first issue. I just had a question I wanted to ask you about your double jeopardy argument.
Yes.
Has any court found that section 113A1 is a lesser included offense of 2241A1?
Not that I have been able to find, Your Honor. And I would reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel. Mr. Graves.
May it please the court, Jeff Graves for the United States. As you're aware, there are many complicated questions concerning the application of the knowing mens rea to 2241 sub A sub 1. So I propose to start with the easy answer that the court touched on at the beginning of the argument. Appellant waived this argument by stipulation. The parties, pursuant to Judge Blackburn's rules, jointly submitted 16 jury instructions, including an instruction that is materially different to the instruction that was actually given. And one additional citation to the record I'd point the court to, Judge Blackburn actually says as much at volume 8, 679, quote, many of the instructions are in fact stipulated to. Our position is that that stipulation precludes review. And moving again to one of the easy answers in this case, any error was certainly not plain. No court has reached this issue. And in fact, the appellant indeed says as much in his opening brief when he refers to this as a matter of first impression. Turning to the end of the conversation from appellant's argument, in order for you to find that there was an actual impact on the trial in this case, you need to believe two things. First of all, that the actual act of digital penetration is the only force that is relevant. That's simply not the case. The forcefulness itself of the penetration is not the issue, but the force that caused the sex act, which is the digital penetration. Here, the court can look at volume 8, pages 172 to 179 for the detailed description of this brutal assault. Mr. Wells beat his victim with a club until she was bloody. He pushed her down onto the sleeping bag, repeatedly kicked her in the stomach, telling her that if there was any chance she was pregnant, the baby would be dead. Ripped off the black leggings, shoved a wooden club inside of her vagina, and then at that point, digitally penetrated her. That's the force that caused the digital penetration in this case. The second thing that appellant must argue is that the mens rea knowingly can be overcome by voluntary intoxication, which it simply cannot be. In fact, if you look at the voluntary intoxication instruction that was given in this case, and that's at volume 1, pages 366 to 67, the jury specifically instructed that for the offenses that don't have a specific intent instruction, they may not consider voluntary intoxication as a defense to those counts. But even if you somehow could do that, even if somehow you could consider voluntary intoxication as to the mens rea of knowingly, the jury was in fact given a voluntary intoxication instruction for count 1. We had to show in count 1 that there was a specific intent to abuse, humiliate, harass, or to gratify the sexual desire of any person. The jury rejected that defense. The instruction, importantly, in this court, looking at the issues raised by Flores-Figueroa and by the Rahaif case, the linchpin in both of those cases is whether or not the instruction that was given would criminalize otherwise innocent conduct. And I direct the court's attention to the instruction that was given and what the jury necessarily found. First of all, that Wells knowingly caused a sex act. Second, the jury found that Wells, in fact, used force. Third, the jury found that the sex act was digital penetration with the specific intent to abuse, humiliate, harass, or to gratify the sexual desire of any person. To believe appellant's argument, the court needs to find that a subjective but unreasonable or incorrect belief that this was accomplished non-forcefully renders all of that innocent conduct. If you look at the context where this statute exists and the legislative history as to how it came to pass, Congress's intent here was to eliminate the problematic doctrine of consent and resistance. Appellant's reading of the statute renders the victim an entirely volitionless object. The appropriate cause of a sexual act is the victim's consent. Even beyond those arguments, grammar is clearly still relevant to this court's interpretation, even after Flores-Figueroa and even after Rahaif. There has been some conflicting lowercase decisions on whether or not.
Mr. Graves, your view is that the way you view the structure of the statute, your view is that the use of force is not an element, correct?
Your Honor, I think that what the jury was instructed of and what we submitted was that did so by the use of force is in fact an element of the offense.
Then don't the Supreme Court cases say that once it's an element, you have to show knowingly? Isn't that the thrust of those Supreme Court cases?
Your Honor, I respectfully would push back on that. I think that there's an implication that there's a presumption that knowingly would extend to that, but there's a litany of examples where that doesn't in fact happen. The Rahaif Court points out the jurisdictional elements. The Ninth Circuit found in United States v. Price, which I understand there was a lot of ink spilled on both sides of that issue, found that knowingly did not extend to the adverbial prepositional phrase. I don't think it's as automatic as appellant would have it. There's no automatic or mechanical application of this. And if you look at the Rahaif decision, there's still the first case that's cited in that decision is still excitement video. The question that they're trying to answer is whether or not a contrary reading would criminalize otherwise innocent conduct. And that's the reason I'm focusing the court's attention on what you would actually have to believe. And appellant really never is able to articulate how someone could use force to knowingly cause a sex act, but have a subjective, unreasonable, or incorrect belief that all of that was not forceful. The only way to get there is voluntary intoxication, which is simply not a defense to mens rea, to this specific mens rea. And Your Honor, I briefly mentioned the Price case, and that is a good example of why this court we have a couple of different ways to avoid that issue because there's competing decisions on both sides, and that case is currently pending a cert decision. But what the Ninth Circuit found there in a similar and analogous statute is if someone knowingly commits a sex act without the victim's permission, because without the victim's permission is an adverbial prepositional phrase, knowingly doesn't reach that. I would submit to this panel that this case is much more clear than Price because we're not dealing with the status of another person or, as in Rahaif, the status of the defendant himself. We're dealing with an action, something that the defendant in fact did. And if you look at the way the jury instruction was written as submitted to the court, that relationship is properly captured. That Mr. Wells did so by the use of force. That is all that is required for a conviction. That's our position. Your Honor, I'd like to turn briefly to, unless there's any additional questions on that issue, I'd like to turn briefly to the multiplicity argument. Appellant finds multiplicity by conflating force and assault. And there's a litany of case law out there that says essentially assault is not force necessarily. That what assault is causing someone to be in a reasonable apprehension of potential force. Force is simply just a different thing. And because there's different elements for 113 sub A sub 1 and 2241 sub A sub 1, those two statutes are not multiplicious. And as this court pointed out in the question to the appellant, there's simply been no decision there's been no case law whatsoever adopting that position. And so we would argue that necessitates that under plain error review, this court can't reverse on that fact. And Your Honors, unless there's any additional questions on either of those issues, the government would ask the court to affirm the conviction, to affirm the sentence, and I would cede the remainder of my time.
Counsel, I have a question about one of the sentence issues, the obstruction of justice issue. I'm not understanding how the apology letter can be an obstruction of justice. Could you explain that?
Your Honor, I think there's two different ways to approach that. First of all, it's a violation of the court's order. It's a violation of the court's order that was imposed at the outset of the case because the government requested in a case involving endemic domestic violence that there be no communication between Mr. Wells and his victim in this case. So that's point one. And then point
but that may be the case that he violated a no contact order, but I don't see where it follows from that we have obstruction of justice. He violated a no contact order. That's not good, but how is it obstruction of justice?
Your Honor, I think that the other component to take a close look at, and this is what was discussed in the McHenry case, from a sister circuit where the court found obstruction, where the defendant, after being convicted, wrote a letter, a seemingly innocuous letter asking for money. The court found that was obstruction. And of course, the context is important. This is a domestic violence victim. This is someone who Mr. Wells knows is going to potentially show up at his sentencing hearing.
Is there anything in the record to show that the government intended to have the victim appear at the sentencing?
Your Honor, I'm not aware of anything in the record. I'm a little biased because, of course, I was trial counsel. What I can tell the court is the victim had the absolute right to be present at the sentencing hearing.
What did the letter obstruct the victim from doing?
Your Honor, our position is that it potentially obstructed the victim's inclination to appear at court and to discuss with the court the impact that this has had on her life. In addition to that, it's very much like the case where the defendant violated a court's order by refusing to give a voice exemplar. It's a violation of the court's order. And if you look at the motion that the government submitted asking for the no contact order, and you look at the order itself, and frankly, the trial testimony in this case, and the government's notice of 404B, this is clearly an instance of domestic violence, and witness tampering is an endemic problem. It's severe, and witness tampering and domestic violence.
Counsel, the trial's over when this letter was sent. I'm not seeing where you've made a witness tampering argument. Let me just ask this: Did at sentencing, did the district court make the requisite findings for an obstruction of justice enhancement? Did it make any findings?
Your Honor, my position would be that they did, that the court did.
Well, what were they?
First of all, the court looked at the letter. I think it's clear from the.
No, I'm asking, what are the findings? Of course, the court looked at the letter, but what are the findings? Did it make any findings other than just pure speculation?
Your Honor, I guess I posit whether this court's going to classify this as speculation, but what the court says that.
I'm asking you. I clearly have an issue with this particular, and I'm not hearing an answer to these questions.
Your Honor, what the court says is that despite the innocuous appearance, it found that it's clear that Mr. Wells intended to exert influence and control over the victim.
Did the court really say that?
Yes, Your Honor, that's at the record, volume 8, page 763.
Okay. Thank you, counsel. Any other questions for Mr. Graves? All right, Mr. G, you have some limited rebuttal time.
Thank you. Judge Murphy, I wanted to get back to your question, and I would refer the court to page 21 of our reply brief, where we talked about the differences between the tendered instruction and the instruction that actually was given during instruction number 12. With regard to the government's argument on multiplicity, it says that we conflated assault and force. Not exactly. We would say that assault is subsumed within force. And assault, as used by the government, is a tort theory of assault, not the crime. And I asked the court to take a look at the jury instructions with regard to this issue. And I see my time is up.
Thank you, counsel. We appreciate the arguments from both of you this morning. The case will be submitted and counsel are excused. The court will take a 10-minute break.
Court is in recess for 10 minutes. The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Our next case this morning is Ashaheed versus Currington, number 20-1237. We'll first hear from Mr. Shapiro. You may proceed.
Good morning, Your Honors, and may it please the court. Colorado prison policy allows Muslim prisoners to keep their beards rather than shave them off. Sergeant Currington knew about the policy, and plaintiff Ashaheed explained that his beard reflected a core tenet of his documented Muslim faith. Currington nonetheless forced Ashaheed to have his beard shaved off on pain of being thrown in the hole, knowing full well this order would harm Ashaheed's exercise of his religion. And the sole rationale mentioned by Currington, that the policy only exempts full beards from being shaved, was false, illogical, and thus likely a pretext. This case comes down to two basic propositions, Your Honors. First, the court should not apply some unusually heightened standard to the construction of the second amended complaint. Rather, apply the ordinary rules of pleading to the allegation of animus and lack of legitimate interest, and the allegations of specific facts that support those assertions. Second, qualified immunity does not shield Currington because it is clearly established that prison officials cannot prohibit key tenets of a faith without any rational reason and based only on hatred for a religion or its adherents.
Mr. Shapiro, on that last point relating to clearly established law, Mr. Ashaheed in the district court relied on the Tennyson case for clearly established law, and you rely on appeal on other cases. And the district court did tell the plaintiff to identify Supreme Court or 10th Circuit on point precedent, and that didn't seem to happen in the district court. So do you have a problem now you've got your bulked up arguments on clearly established law, but was the burden ever met in district court, and does that present a problem for you at this point?
It does not, Your Honor, and the reason it does not, well, first of all, the other side has not asserted any waiver issue, as far as I understand, with regard to that, and moreover, they could not, because waiver means that you have to press the same claims and press the same arguments. It has never, to my knowledge, been pressed to the hilt to such an extent that it means that you need to rely on the same cases. Moreover, this is an obvious violation of a clear constitutional right, and therefore qualified immunity is overcome regardless of a specific case that is directly on point. Indeed, the Supreme Court recently reaffirmed in the Taylor versus Riojas case a principle it had enunciated previously in Hope versus Peltzer, which is that you don't need a case that is factually similar where a violation is obvious. And it is obvious across the board that that government officials violate the First Amendment when they repress the exercise of a faith based solely on animus directed toward it, which is adequately pled in this case. And indeed, this court said in the Shrum decision, proof of hostility or discriminatory motivation may be sufficient to prove that a challenged government action violates the free exercise clause. This is not the sort of situation where there is a complex factual texture that makes a legal rule difficult to apply, say in contrast to, say, the excessive force context, where the court has required a higher level of specificity, where there are factors like, did the plaintiff have a weapon? Was the situation evolving quickly, et cetera? This is the sort of situation where a legal rule is evergreen for all seasons and across the board. You do not, as a government official, repress the exercise of someone's faith based on animus, whether it is diet, whether it is grooming, whether it is going to the chapel. If you are motivated by animus and you are repressing a core tenet of someone's religion, that is a violation of clearly established law. It is.
Counsel,
Yes,
can you? I noticed in your brief you didn't really discuss, at least in the clearly established discussion, you didn't really establish or discuss the Holt case, and I understand that was in a different context, obviously. But why isn't it helpful here to you, or do you think it is in the clearly established inquiry?
I do think it's helpful, Your Honor, and we did cite it in the briefing, as your question noted. It arises in the RLUIPA statutory context as opposed to the First Amendment context. But in practical terms, there is a Supreme Court case involving beards and the exercise of religion. That's data point one. Data point two is there is a policy that Currington is responsible for enforcing that says there is a right to have a beard if your faith is properly documented, as Ashaheed's was, and with no possible basis for this ludicrous freelance exception that Currington appears to have invented for if you can't grow a beard that is of sufficient length. On top of that, there is the provision or the reality that is simply clearly established as an obvious matter of free exercise law, that the government cannot repress religious exercise on the basis of animus. And then, as if that were not enough, there is the fact, there is the Grayson case from the Seventh Circuit that addresses animus in the context of a prison grooming regulation. And there is the unpublished Matthews case in this court, which says essentially the same thing. And Matthews holds not only that there was a constitutional violation, but that it is clearly established. And so if the law was so clear that the Matthews panel thought that it wasn't breaking any new ground, that there was even any need to publish a decision holding that it was clearly established.
Well, you can't read that into an unpublished decision. You can't read the court's intent or thought process. There could be any number of reasons to unpublish a decision. Go ahead, I'm sorry.
I understand, Your Honor, but I think that the reasoning is quite clear and quite persuasive in the Matthews case, as well as in the Grayson case, and shows that it is simply a clear, settled core principle of American constitutional law that the government cannot oppress the exercise of a faith on the basis of animus for that faith.
Mr. Shapiro,
yes.
Your position is that in an animus-based claim, the justification for regulation that has peniological grounds for it, that's irrelevant. That's your position when it's an animus-based claim, correct?
I wouldn't say that, Your Honor. I want to be very clear. I have no problem with the regulation itself or with the rationality of the regulation and the fact that the regulation itself is animus-free. We are challenging Currington's freelance departure and violation of the regulation. The regulation very clearly says that a prisoner such as Ashaheed, whose faith is properly documented in the prison system, does not have to have his beard shaved. And Currington flagrantly violated that rule by forcing Ashaheed to submit to being shaved or to be thrown in solitary confinement. That's the crux of the claim.
Okay, then that's you're basically saying it is not a Turner claim. Isn't that what you're saying? That's what I read, what you just said. This is not a Turner claim.
I would clarify it in this way, Your Honor. There are two strands of the First Amendment claim, both of which are sufficient independent claims. One is a claim that an animus-driven religious discrimination claim. The second is I would call it a Turner claim. This court made clear in Bowles that a Turner claim does not just mean that there needs to be does not always involve a policy that does not have a rational penological interest. It can also be applied to action by a prison official that lacks a legitimate penological interest. And the Second Circuit said the same thing in the Salahuddin case cited in our brief. And so our argument is that there was simply no rational justification for Currington to flagrantly depart from policy and to force Ashaheed to shave his beard. And the rationale.
Counsel, could I just follow up on that? Once you've explained it that way, it doesn't seem like the second strand and the first strand are all that different. Both are simply based on intentional action by Sergeant Currington. Don't the strands tend to merge once that's the premise of the complaint of the claim?
I think that in this case there is some merger, and there may be some merger in other claims based on the facts, but that they are analytically distinct. Because one can have a Turner claim based on an official's action that is undertaken not necessarily with animus, but with no legitimate rationale whatsoever. And that would, and if religion were repressed in that way, without a legitimate rationale, but also without animus, that would be sufficient to state a Turner legitimate penological interest claim. But for purposes of this case, ultimately, I agree with you, Judge Matheson, because much of the evidence intersects. The fact that that Ashaheed was treated in this rude and gruff manner, the fact that it was a clear departure from policy, the fact that the rationales that have been offered by my friend on the other side ultimately don't make sense, ultimately support both the fact that there is no legitimate penological interest here, as well as the fact that this was action that was undertaken on the basis of animus, and that the proffered reasons are pretextual.
But what you're saying there is that you could have this Turner claim where the jury would not have to find religious animus, but they would have to find an animus related to arbitrariness, correct?
I'm not sure that I would characterize it as an animus related to arbitrariness, in the sense that it is that I understand the Turner test.
Then it would be arbitrariness. It would be unrelated to anything. You would not have to show any animus towards Islam, correct?
That's correct. It is a claim that religion was. Oh, I'm sorry. Yes.
Doesn't that mean it is no longer the First Amendment? It has nothing to do with religion.
No, Your Honor. The motivation does not necessarily figure into the Turner style analysis. It is an objective inquiry as to whether there is a legitimate and rational reason for a limitation of the exercise of faith.
Well, then, look, I mean, I think Judge Matheson has a very interesting point. Then what we have to do is we have to anticipate how this First Amendment claim would be presented to a jury. So you would have a jury instruction. And I don't see how you would have anything but a single jury instruction on this claim. Can you tell me how you would instruct the jury?
Yes, Your Honor, I can, and then I'd like to reserve the limited remainder of my time. The jury would be instructed that you can find a First Amendment violation either because Ashaheed's religion was repressed on the basis of animus, or because it was repressed without any rational connection to a legitimate penological rationale. I'll reserve the remainder unless there are further questions right now.
Mr. Shapiro, I will try to. I'll try to give you a little rebuttal time, but I can't. I think it would be best not to wait until then to ask you this question, because you have not touched on your equal protection theory. You have a free exercise theory, you have an equal protection theory. And could you briefly tell us what is your best authority on clearly established law on the equal protection claim, and particularly on the similarly situated component of equal protection?
Well, first of all, Your Honor, it's not clear to me that the clearly established analysis goes to the nature of the comparator. We're arguing that the clearly established principle, for purposes of the Equal Protection Clause, as well as for purposes of the Free Exercise Clause, is that you cannot discriminate against people on the basis of animus for their religion. In terms of the comparator, I think the best way to view it is that the policy creates an exemption which which Currington is alleged to have followed when it comes to Christians and Catholics wearing crosses. But he departs from the same policy when it comes to wearing a beard. So it's not for Muslims. So it's not just this abstract comparison of crosses to beards. It is that there is a policy on religious exemptions and religious accommodations. And Ashaheed and the comparators are similarly situated in that their exercise is similarly protected by the policy, but they are treated disparately because Currington follows the policy when it comes to Catholic inmates and their exemption, but departs from it when it comes to Ashaheed and
okay, I understand your argument, but just to be clear, to the extent that you need to establish, you need the clearly established prong of qualified immunity. Are you relying on an obviousness theory there, as you articulated earlier in your argument?
Yes, on the theory that it is obvious that under the Equal Protection Clause that government officials cannot discriminate against faith based on animus.
Okay, thank you. Thank you.
Thank you.
All right, Mr. Luna, you may proceed.
Good morning, and may it please the court. My name is Josh Luna. I represent the defendant appellee, Thomas Currington. Here, the Colorado Department of Corrections general policy requires all inmates be clean-shaven during the intake process and provides a narrow exception for inmates who wear a beard due to a sincerely held religious belief. Now, as this court knows, Mr. Ashaheed bears a heavy two-part burden to overcome qualified immunity by showing first that Mr. Currington violated his constitutional rights, and second, that the right was clearly established at the time of the violation in the particular circumstances faced by Mr. Currington. It's our position that Mr. Ashaheed has failed to meet his burden on either prong. And I think that it's helpful to start with the claim for religious discrimination. And in particular, the Iqbal standard is clear that in order to plead a religious discrimination claim, the plaintiff must establish a discriminatory purpose. And that is a decision maker's undertaking of a course of action because of, not merely in spite of, the action's adverse consequences.
Counsel, could I just interrupt for one clarification? When you say the religious discrimination claim, I'm not clear whether you're talking about the free exercise claim or the equal protection claim.
Well, Your Honor, and I can clear that confusion up at the outset. It's our position, as the district court voiced this concern as well, that it's clear that Mr. Ashaheed is trying to pursue a religious discrimination claim. And this court in Carr versus Wally noted that, when that's the theory, it's the Iqbal standard that applies.
Well, no. Are you relying on, is the claim, are you responding to a free exercise claim, or are you responding to an equal protection claim?
Responding to the free exercise claim.
All right.
As well as the equal protection claim, too, Your Honor. I mean, we're not ceding that point as well. But
okay,
in particular,
go ahead.
Yes. But in particular, in looking at the particular allegations for the religious discrimination claim, it's clear, as Mr. Ashaheed admits in the complaint, that initially Mr. Currington sought to abide by the general policy by requiring him that he shave his beard, as is the case with all incoming inmates. And then we have this full beard colloquy, that Mr. Currington stated that he needed a full beard in order to qualify for the exemption. Now, my friend on the other side argues that that's so illogical and absurd that it infers only animus, but they didn't plead a claim that this was a pretext at all. Nor are there any factual allegations that would let this court reasonably infer that Currington invented or concocted this excuse. Rather, on its face, all that it plausibly suggests is that Currington was mistaken about the exception to the general policy. And in particular, Your Honor,
isn't that a very fine line to draw when you're dealing with a 12b6 motion versus a motion for summary judgment? I mean, it seems to me that you are saying that there are two inferences can be drawn, and because it's not pled right, you draw this inference. That seems to me what you're saying.
Well, Your Honor, I think that this goes back to the standard. The burden that Mr. Ashaheed had to plead was because of, not merely in spite of, discriminatory purpose with respect to his religion. And there are no facts indicating that Sergeant Currington acted out of animus for Mr. Ashaheed's faith. You think that as the facts are alleged, there is no legitimate inference that it was animus based on his religion? No, Your Honor, and that's because the full beard discussion on its face suggests a simple mistake. There are no other allegations suggesting
does it completely negate the inference of animus base, or does it just provide a possible different inference?
No, Your Honor, I think that it suggests only a mistake on its face. There are no other allegations. If we look to other cases on which Mr. Ashaheed relies, the Marshall case, for instance, that there they made the plaintiff shave because they didn't like his religious hairstyle, and then once it began to grow out again, they harassed him about it. Here we have nothing else. We have no statements suggesting that this was because of Mr. Ashaheed's faith, as opposed to because of a confusion or a mistake or a misapplication of the exception to the general policy, and a belief, a reasonable but mistaken belief, that the general policy requiring all inmates be clean shaven on intake applied. And in particular, Your Honors, I want to touch on a couple of points.
Does it matter that he threatened that Currington allegedly responded, that he didn't want to hear about it, that he threatened retaliation, stating that Ashaheed would be thrown into the hole, meaning solitary confinement and isolation? Doesn't that add to the inferences we can make here?
Well, Your Honor, it certainly is within the court's purview to consider those statements, but I think it's important to look at the context of those statements.
Are we required to look at those statements? Aren't we required to add them to the mix? Isn't that exactly what our job is?
Yeah, yes, Your Honor.
How can we possibly just say, well, we can look at these statements and we can just assume this was just a big mistake?
Well, Your Honor, I think that
it's not supported. I think
as is alleged in the complaint, that statement, the didn't want to hear about it, occurred after this full beard colloquy already, which on its face suggests a mistake.
It occurred as part of the whole process. It wasn't a separate day later comment. This was part of the entire event.
Yes, Your Honor, and I think that touches on another
extremely
concern.
relevant.
I think that touches on another another fact that's stated in the complaint is just sort of the context of the prison intake system. It's clear they're going through classification, they're documenting his religious faith, and then moving him on for a physical examination, documenting his tattoos, as well as, having him shower, and then they're going through this process. And I think in context, all that plausibly suggests is Sergeant Currington had heard him out. He mistakenly believed that that you needed a full beard in order to qualify.
Those are your inferences about what he mistakenly believed. We can't get those inferences from here.
I think that the statement that he didn't want to hear about it is a reflection of simply trying to move him along.
You think it is. I'm asking, what can we infer from the facts? And I don't think we can infer what Mr. Luna thinks.
Understood, Your Honor. And in the particular context of the complaint as it's alleged, the facts demonstrate, while it didn't want to hear about it isn't a sugar-coated response, it says nothing about Mr. Ashaheed's religion. There are no similar statements like, I don't want to hear about it. I don't want to hear about your religion, or I don't believe what you believe. Or
how about threatening retaliation, threatening to throw him in solitary confinement? Can't we make some inferences from that extreme response to his assertion of his religious rights?
Well, Your Honor, that is a reflection of what may happen in the prison setting when the officer gives what he believes to be a direct lawful order and is meeting resistance with that. It has nothing to do with that it was because of Mr. Ashaheed's faith. And that's the standard here. We don't have any allegation showing that Mr. Currington allowed inmates of other faiths to keep their beard, or any inmates of any faiths.
Mr. Luna, in I would say a minute and a half of the portion of your exchange with Judge Moritz, you used the expression context at least 5 times. Is context an appropriate matter in a 12b6 consideration? Or is it more appropriate that you address context at summary judgment or trial?
Well, Your Honor, I think that this touches on another point that I wanted to turn to, which is qualified immunity. And there we're told that the particular circumstances and the context do matter. At bottom, all that is alleged here is a single instance of a failure to recognize Mr. Ashaheed's entitlement to the beard shaving exception from the general rule. We have this colloquy that on its face plausibly suggests a mistake about that. And that kind of cuts to the core of qualified immunity, which is to give government officials ample room to make reasonable but mistaken judgments. And in looking,
possibly suggests that, but that does not eliminate that it plausibly suggests the opposite, does it?
Well, Your Honor, we don't have any statements. It's the plaintiff's burden to paint a picture to show that he was discriminated of, not in spite of his religion, but because of his religion. And in some of the other cases that we have, Marshall versus Wyoming Department of Corrections, as I said, we have sufficient factual allegations that they targeted this specific inmate because of his religious hairstyle and forced him to shave it because they didn't like it. We don't have any similar statements of indicating animus. We don't have any expressions, facial expressions or laughter or anything that, coupled with the facts here, may plausibly state a claim for religious discrimination, but on its face, all it suggests is a mistaken application of an exception to a general policy. And in particular, Your Honors, I think there's this notion that violating a policy somehow equates to a constitutional violation or constitutes clearly established law for qualified immunity purposes. And the Supreme Court and this court have soundly rejected those notions. And in particular, Your Honor, Judge Moritz, I'd like to touch on Holt versus Hobbs for clearly established purposes, because in particular there, the Supreme Court confronted a prison system that disallowed beards entirely. And the court observed that prisons have a compelling interest in the quick and reliable identification of inmates. And as the petitioner suggested in that case, the court could, the court stated that, the prison system could meet its really exacting burden under our LUPA by requiring inmates to be clean shaven when they first arrive at a facility, photographed, and then allowed to grow their beards out. So essentially what we have here is on the clearly established ground, we have one unpublished decision in Marshall that Mr. Ashaheed relies on to show that this was a clearly established violation. And on its face, that's insufficient to constitute clearly established law. First, as this court has repeatedly held, a single unpublished decision is insufficient to show that the law was clearly established on a given point. And second, even if it were sufficient, Marshall is too dissimilar from this case to have given Mr. Currington fair notice that his conduct was unlawful. And there, in particular, as I've touched on the facts a little bit earlier, the prison system generally allowed inmates to wear religious hairstyles. And the plaintiff alleged in that case that prison officials essentially targeted him, forced him to shave his religious hairstyle, and then after he was transferred to another facility and it began to grow out, they harassed him about his religious hairstyle again. On its face, that plausibly establishes, because of discrimination, a pattern of consistent targeting and discrimination because of his religious hairstyle. Whereas here, all that we have...
Mr. Luna, let me ask this, and this has to do with how a court is to construct a pleading under 12b-6. Is there any indication in that amended complaint of how it was that the officer got the idea that the religious rule on the beard required a full beard? Is there any indication where the officer got that?
No, Your Honor, but I think it's...
Doesn't that raise the inference that the officer was really focusing on the religion? He knew about this. He knew that the religious rule was that it was a full beard, not a little scraggly beard. Isn't that an inference?
No, Your Honor. I think that it reflects a simple mistake. And, it's important to note that the policy itself isn't the only documentation around beards.
No, we're not talking about a mistake about the religious view. You're saying it was a mistake on applying the policy. I'm talking about the religious concept of having a full beard. This officer knew something about this that is not anywhere discussed, and that is he knew that the Islamic requirement is it is a full beard, not a scraggly little beard.
Well, Your Honor, I think getting to the notion of the documentation that officers are provided on this, there is documentation from the Office of Faith and Citizens Programs that notes corrections officers could expect inmates, such as Muslim inmates or Sikh inmates who oppose shaving their beards due to religious tenets, could expect a full beard on intake. And that may help explain some of the context around this. I see that my
Of course,
time
that would take us outside the record, wouldn't it?
Your Honor, it's actually on page 183 of the record. In the first
I'm
response.
talking about outside of the complaint, which reminds me, I guess I'm a little, the complaint itself didn't have anything attached, right?
No, Your Honor.
What are you referring to when you say page one?
Yeah, what is page 183?
In response to the first motion to dismiss, Mr. Ashaheed's counsel attached a series of policies, and this particular guidance is from the Office of Faith and Citizens Programs, and it is in the record.
But it doesn't matter if it's in the record. I guess that was my question. I question why anybody's talking about any of that, because this is a motion to dismiss, and the court didn't convert it to a summary judgment motion, and nobody talked about the fact that these were entirely outside the complaint pleadings. I'm confused by that. It may be in the record, but it's not something that we can review.
I understand, Your Honor, and I see that I am out of time. If I could just briefly conclude.
Well, you are out of time, but I'm going to ask you an equal protection question, just like I did Mr. Shapiro. Why weren't the allegations that other inmates received religious accommodation to keep religious materials enough to allege an equal protection claim here? I understand that keeping a Bible versus keeping a beard is factually different, but is there really any difference in terms of receiving a religious accommodation? Here, the accommodation would be the exemption, so he keeps the beard. Then he alleges that accommodations have been given to other prisoners. Why isn't that enough?
Well, Your Honor, I think that there are a couple of points to your answer. We don't have any allegations about what the policies were on as to religious items or how broad or narrow those exceptions were, and so it's tough to compare that on its face. But even putting that notion aside, this court's precedent is clear that for similarly situated for the similarly situated analysis, the people must be alike in all relevant respects. And that's plainly not the case that we have here.
Counsel, why aren't they alike in that they're both seeking accommodations based on their religion?
As the district court noted in its final order dismissing, religious items don't change one's appearance, as does beard. That's a first instance, and also the notion that taking Mr. Ashaheed's arguments on appeal to the logical end, the notion that you state a plausible claim for religious discrimination, which again we contest that. The notion that you state a plausible claim for religious discrimination as a matter of law also states a claim for equal protection that runs directly contrary to this court's precedent.
Mr. Luna, have you ever been in a trial court where prisoners are brought up and the prison priest has handed out to all of the prisoners, if they so choose, a rosary that goes around their neck? And so when you're observing them, it looks like part of their dress. Have you ever experienced that?
I have not, Your Honor.
Okay, thank you.
And for these reasons, we would ask that this court affirm the district court's dismissal of this case. Thank you.
All right. Thank you, counsel. Let's give Mr. Shapiro 1 minute.
Thank you, Your Honor. I take it that it is sufficiently clear at the pleading stage that there are sufficient allegations of animus, and that the law is clearly established under the Free Exercise Clause that government officials cannot discriminate against religious exercise on the basis of animus. So I want to briefly clarify 2 doctrinal points. First, as to the Equal Protection Clause, the principle is quite clearly set out in United States versus Batchelder. The Equal Protection Clause prohibits selective enforcement based upon an unjustifiable standard such as race, religion, or other arbitrary classification. And it's clear enough that that is what's going on here, at least for purposes of 12b-6. Second, as to the question that we discussed a bit at the end of my original presentation as to Turner as applied to individual actions, I want to direct this court to the Bowles versus Neat decision, which says that an individualized decision to deny a prisoner the ability to engage in religious exercise is analyzed in the same way as a prison regulation denying such exercise. So it's the same rationality and legitimate penological interest analysis. Thank you, Your Honors.
And that case is cited in your brief.
Yes, it is, Your Honor. I'm right now I'm looking at pages 16 to 17 of our reply brief, but I know it's also cited in our opening brief. Bowles versus State.
Thank you. Any other questions? Right. Thank you to both of you. Very interesting case, and the arguments well presented and helpful. So thank you very much. The case will be submitted and counsel are excused.
Thank you, Your Honors.
Oh, oops.
Right. Our final case this morning is United States versus Lumoli, number 20-4091. Counsel, you may proceed. Mr. Sanderford, you can start us off.
Thank you. My name is Dean Sanderford from the Federal Defender's Office, and I'm here for Viliami Lumoli. The issue in this case is whether Mr. Lumoli's waived his right to challenge his conviction by waiving the right to challenge his sentence. He didn't, because no matter how broadly the term sentence is construed, it doesn't include convictions. Convictions and sentences are conceptually distinct. Convictions an adjudication of guilt, and a sentence is the punishment imposed. A conviction is just not part of a sentence. The definition of sentence that's in the collateral attack waiver in this plea agreement confirms this. It says that sentence refers to, quote, all aspects of a court's sentencing authority, and the examples it gives are fines, restitution, imprisonment, supervised release. These are all parts of the sentence. They're all part of the punishment. Yes, it's true that that list is non-exclusive. The plea agreement says that, but there's no reason to think that any unmentioned aspects are anything other than punishment, anything other than a part of this sentence. The district court ruled, and the government argues on appeal, that a conviction challenge is necessarily also a sentence challenge, because if the conviction is vacated, the sentence is vacated as well. That's not true. A sentence challenge challenges the sentence. It alleges that there's an error in the sentence or in the manner in which it was determined. A conviction challenge, by contrast, challenges the conviction. It says that there was an error in the conviction or that there's something otherwise wrong with it. This distinction between conviction challenges and sentencing challenges is reflected in the way parties write plea agreements all the time. When parties intend to waive both, they specify it. They waive them explicitly and separately. You see this in hundreds of this court's cases. Lawyers are known to use a belt and suspenders approach. Sometimes they're redundant, but there's no reason to think that's what's going on here. There's no authority outside the District of Utah for this notion that you waive a conviction challenge by necessity whenever you waive a sentencing challenge.
So, Mr. Sanderford, let me ask you to respond to this argument about the wording of Section 2255, which uses the word sentence and does not include the word conviction. And I understand it's been interpreted to permit challenges to convictions. But my question to you is this. To rule for you on this appeal, do we need to hold that the word sentence means something different in the plea agreement than it does in Section 2255?
I don't think you have to, but that's certainly one basis. I mean, no matter how 2255 is, the word sentence is interpreted, the parties defined sentence in the plea agreement, and parties can define terms however they want. And this notion that it includes 2255 challenges of convictions is just not in the plea agreement. Sentence was defined as aspects of the court's sentencing authority. And no matter what 2255 means, that it's not an exercise of the court's sentencing authority to enter a conviction. But in any event,
well, I'm looking at the plea agreement and in particular the waiver, and there is specific reference to Section 2255.
Yes, there is. He's waiving challenges to his sentence brought by way of 2255. I mean, that's how the plea agreement is worded. It's a collateral. I keep calling it an appeal waiver. It's a collateral attack waiver, and it says you're waiving all collateral attack challenges to your sentence, including by way of a 2255, which is just one means of bringing collateral attack, really the main way of bringing the collateral attack on a sentence or conviction. But nowhere in that definition does it say that the word sentence includes challenges to convictions under 2255. I think in any event, the government's wrong that the use of the word sentence means convictions in 2255. I mean, we discussed this in our reply brief, but the history of the provision is it was just a venue changing provision. It was a habeas corpus. It preserved all the rights of habeas corpus and just moved venue to the court of sentencing rather than the court where the prisoner was confined. And what the Supreme Court said was like, look, this is still just the right of habeas corpus as it always was. You just file in this court instead of that one. So there's really no reason to think that, well, the Supreme Court certainly didn't hold that, well, the term sentence means convictions in 2255. I think kind of in a broader sense, and I don't have any authority for this, but I think it might make sense that, habeas corpus is traditionally a challenge to illegal confinement. And only people who are in custody can file habeas corpus applications, including 2255s. So it makes sense in that context that Congress would use the word sentence and focus on the word sentence, because at bottom, what the prisoner is challenging is his or her confinement, and that the confinement is obviously as a result of the sentence. But that doesn't mean you can't challenge convictions under that statute as well. This is jumping ahead a little bit, but I want to make sure I don't forget about it. There's this Baker case out there that is most likely going to decide the merits of Mr. Lumoli's 2255 claim. So if this court is inclined to reverse, we suggested in the brief, well, and certainly the court has the power to hold it. The court can do whatever it wants on that. But we would ask that you not hold it. And that's because any delay in resolution could prejudice Mr. Lumoli. If this court holds pending Baker, then if Baker comes out his way, we'd have to wait for a decision from this panel on this issue and a remand back to the district court after any rehearing proceedings. But Mr. Lumoli has already served.
Baker was argued this week.
It was argued on Wednesday. That's correct. But
so you're asking us, if we agree with you, you'd ask us to vacate it and immediately send it back. Don't abate in this court, send it back to the district court.
That's right. And it really is just...
District court can still abate itself.
That's true, but he'd be further along the road. He wouldn't have to wait for this decision and a remand, and maybe the government seeks rehearing. He's already served 13 years. And if he prevails on the 2255, if Baker does, then he's only looking at a mandatory minimum of 10 years. So, we would ask that you move ahead with this appeal without waiting for Baker.
I see.
Unless the court has additional questions, I think I've covered my argument. I don't need 8 minutes in rebuttal, obviously, but I'm happy to reserve whatever you'll give me.
Well, you can have it if you want it, but we'll see. All right, Mr. Tenney.
Thank you, Your Honors. Ryan Tenney on behalf of the United States, and may it please the court. Rather than going with my prepared intro, I think I'm just going to start where Mr. Sandiford left off. If I understood what he just said that if Baker prevails in Baker, then Mr. Lumoli would only be looking at a mandatory minimum of 10 years. And that's precisely our point. He says in his reply brief, that what he's asking for would only have a, quote, indirect or an incidental effect on his sentence. And yet what he's saying in argument is the thing that we think is obvious and unavoidable, which is that if he's right on his challenges to his convictions, there is no choice procedurally but to vacate his sentences and reduce them.
It's just a function of criminal procedure. That's not, he's got to challenge his conviction before he can get that sentence that would go along with it. I don't find that confusing.
I agree with you, Judge Meritz. And that is our point, is when the government engages in this plea negotiation and helps craft this plea agreement, the thing that the government thought it was getting out of this is precisely this, because as you put it, this is how criminal procedure works. The government thought...
Well, I don't think we're thinking alike on this, Mr. Tenney. He's challenging his conviction.
He is, but what I understand...
Might result in a different sentence, which is what he would hope. But it's not complicated.
Right. We don't think it is either, but we think it's not complicated. I sense in perhaps the different direction. What we're concerned about is the validity of the plea agreement that the government and Mr. Lumoli negotiated. And what the government thought it was getting out of this was an agreement from Mr. Lumoli that he couldn't go after his sentences in a 2255 conviction. And if what he's acknowledging is that the natural result of his proposed argument is that his sentence be reduced by 25 years, then he's asking for the thing that we believe he agreed to not ask for. And this kind of comes back to our overarching...
May have been your intent, but looking at the plain language of your waiver, the waiver of the collateral attack, I don't see where the government can make that argument.
Well, this is where we get there, Your Honor. And I respect where you're coming from, and I acknowledge this is one of those cases that you can look at it one way and you can look at it another way. This is why we think our way is better. Is the question on, if the question on appeal were what the term sentence means, I think we would lose ordinarily. But that's not what we think the sole question is. What we think the question is what subprovision 8D means. And what 8D says in total is that he's, quote, knowingly, voluntarily, and expressly waiving his right to challenge his sentence in a collateral review motion, including those brought under 2255. It's that complete context, Your Honor, which we think brings it to our point of view, which is the thing he was agreeing to not do was challenge his sentence in a 2255 motion. 2255 motions routinely use the word sentence to include conviction challenges. They have to statutorily.
And so, how did you define sentence?
Well, in the 2255 context.
How did you define sentence in the plea waiver or in the?
Well, in that would get you to paragraph F, which would be the sentence is being used broadly, and then it gives the list. But
so that's what we have to look to, not 2255, but how you defined sentence in the waiver.
Right, but I don't think you would excise subsection D from that analysis either, because you interpret a plea waiver as a whole. You interpret all the parts in harmony with each other. And so if D and F are being read in harmony, because D is the waiver provision and then F is the definitions provision for the waiver provision, I don't know that you would be able to excise D from this analysis. I think you read them together. And if you read them together, what the parties are talking about is a challenge to a sentence under 2255. Well, the thing that he's wanting to do is, by statute, a challenge to a sentence under 2255. That is the thing he's trying to do. And he makes the point, the historical point about the passage of the statute and its relationship to the traditional writ of habeas corpus and so forth. And I understand the point, but what we're ultimately talking about is a statute. Congress replaced the writs with the statute. And so that's a function of how the statute is interpreted. And the word that the statute uses is sentence. And what the courts have done with that word in that context is said that includes a challenge to a conviction. And so when the government helps draft this plea agreement, I think it could rightfully look at this universally understood context and just track the statute. That's what this plea agreement does. It tracks the statute.
I'm sorry. Go ahead.
Oh, go ahead, Judge Moritz.
I was just going to say, apparently the government in some cases knows how to draft an agreement that uses the word conviction, because that's the Pam case, right?
Yeah, and
that's not all that hard either.
I certainly agree that it would not have been hard to have added those extra words, and it would have spared me some time this week if they had. But here's my response to that, if I may. The fact that there would have been a better way to have put this doesn't mean that the government's not entitled to the reasonable construction of the way that it was put. And so I will readily concede we could have drafted a better agreement. And if we lose this case, I suspect we probably will. But
you might even do so if you win this case.
We might even do so. Although if we win and it's a published opinion, I don't think we'll have to. But the point is even though in any other contract analysis, you're not going to say, because this is the most optimal way, everything short of that, we're going to spin it the opposite direction. So it would have been more optimal, Judge Moritz, I'll readily acknowledge, for us to have said conviction and sentence. But those who drafted this agreement thought that the word sentence in 2255, it was obvious to everybody what it means, because this is the only thing it can mean statutorily. So when he agrees to waive that, that's what they thought he was waiving. And it gets to this question that's raised in the reply brief, which is the impact of his own understanding of this.
Before you get there, I've got another question, but I don't want to butt in before Judge Matheson, but I've got another question related to this. When you're talking about that agreement, do you know how long you've been using that agreement?
I don't know, but this is a pretty old case, because this trial happened.
Well, I mean, it looked to me like there were a number of cases back several years ago where there was some question about what sentence means, and that's why you might have added the definition of, in this case, that sort of broadened it to make sure it included supervised release and probation, that sort of thing. It looked to me like this definition might have been specifically added in to deal with those types of challenges that really were about the sentence. So I just wondered if you had any information about that.
Here's what I'd say about that. I don't know the historical lineage of that particular clause. I know that it was there at least as of 2008, because that's when this agreement was, and I know that it's still there now in the agreement that our office is using. We have at least those 13 years. But then going more particularly to the point you just made, if we are then going to move outside to the sort of colloquial understanding from other sources, then I think we really win, because then the most obvious colloquial outside place to look is 2255.
I'm not saying that we should go there. You were talking about several mentions of the government's intent there, and I just thought maybe the intent might have been otherwise. So.
Right. Yeah, I can't speak to that as specifically. As to the
Mr. Kinney,
please.
Isn't your argument premised on this court construing the agreement in your favor?
Yes, we want you to construe the agreement in our favor, yes.
And is that the way we're supposed to do this?
Ordinarily, no. Ordinarily, it is construed against the government. This, we think, is the...
Why is this the exception to our ordinary protocol?
Because of the broad interpretation clause. I think that's the most important component of that clause. I think it also shades how you look at the term. I think it works on both levels. But I think the most direct thing that it does is take this outside the normal rule of construction that these agreements are construed against the government, because the parties are expressly saying but they're not saying the opposite 100%, but they're saying broadly. And broadly is the opposite of narrowly, which is what those cases say.
What if the agreement, instead of saying broadly, said this agreement is to be construed in favor of the government? Would that be okay?
I think the parties could agree to that, yes.
And that would bind the court.
I believe so, yes, because these are treated as contracts. And so the parties could negotiate that term. I believe so. I can't think offhand why that would be unlawful.
But as Mr. Sanderford pointed out in subsection F, yes, it does say construe the word sentence or understand the word sentence broadly, but then all the examples that follow that are sentencing examples.
That's true.
It doesn't say including convictions.
That's true. And I think in an ordinary case that would, I think, be more problematic for us, but the language that gets us out of that problem, we believe, is in the middle of sub F. It says including but not limited to. We haven't gone this deep in the briefing, but there's a line of, I wondered if this was going to invoke adjustum generis, that canon. And there's a line of cases from this court on the adjustum generis canon that say that if you have that phrase, a phrase like that, including but not limited to, it takes you out of that canon. And so we think the import of that canon is of that language within F is to say, here's a list of things that are clearly covered, but you can go beyond that too.
Let me ask you this. You've argued in your brief that a defendant cannot challenge his convictions without simultaneously challenging his sentences. Yeah. Is there any way Mr. Lumoli would be able to challenge his conviction after completing his sentence?
He'd have to fit it under some exception within the plea agreement. I don't pretend to have memorized the plea agreement, but we would be able to invoke the waiver as far as the waiver goes.
Well, but he didn't waive a challenge to conviction. And
you're saying
no longer have a sentence.
Maybe I'm misunderstanding. You're saying if it was something other than a 2255?
Well, I suppose that if it were a 2255, even if he were on supervised release, I suppose he's still serving his sentence. And then if that's done, then 2255 may not be. Let me give you another scenario. What if a defendant had been sentenced to equal concurrent sentences on multiple counts? Could that defendant, under this plea agreement waiver, bring a 2255 challenge to one of his convictions, even though a successful challenge wouldn't reduce his period of incarceration? Just more interested in taking one of the sentences off his record, or one of the convictions off his record.
My instinct is that the answer is yes, because he's still challenging his sentence. And I, in the back of my mind,
how is he challenging his sentence? It wouldn't change his sentence. It would just take one of the multiple convictions off his record.
Because if I understand the way the system works correctly, there may well be downstream implications with BOP or somebody else relating to how many of the sentences are still in play. And so our interpretation of this is when he says he can't challenge a sentence, that just means he can't challenge a sentence, period. And if he had wanted to negotiate a reservation on that for that kind of provision, he could have, but he didn't. That would be our response to that. The point that I was wanting to get to earlier that I wanted to make sure that I addressed, because I think it helps clarify some of the issues raised in the reply brief, is the impact of his alleged misunderstanding about his term, or quite frankly, maybe it is his misunderstanding. I'm not in a position to contest that. We don't think that that particular argument is quite proper here because of the way that the Hahn factors work. The Hahn factors for interpreting an appeal waiver have, of course, 3 steps. Step 1 is the scope of the waiver. Step 2 is the defendant, whether he knowingly and voluntarily entered the waiver. And then step 3 is the miscarriage of justice. The only thing that you've granted a COA on is step 1, which is the scope of the agreement. You haven't granted a COA on step 2, which would be, did he understand? Did he know the scope of the agreement? Or did he know what he was waiving? And that's why, this circles back to what we argued in our brief. That's why this court's cases, although they have said on step 1, we use contract principles, the test has ultimately been framed as an objective one. It's what a defendant's, quote, reasonable understanding would be. And the reason that makes sense is because when you treat step 1 as a question of law, what you're looking at is what a defendant would reasonably understand, meaning what do these terms mean legally? And you don't need to look any further than Pam to see how this plays out. When the parties litigated in Pam what the word conviction meant, you didn't remand for the prosecutor to get on the stand and say, this is what I think conviction meant in this case, or you didn't get the defendant on the stand and say, this is what I thought conviction meant. What you said is, no, for step 1, as a matter of law, this is what a defendant would reasonably understand the term conviction to mean. And so you would do the same thing here. You would say, as a matter of law, what does a challenge to a sentence in a 2255 mean? And if Mr. Lumoli then wants to say, okay, well, I didn't know that, that would be a step 2 claim. But he didn't make that step 2 claim in his petition, and you haven't granted a COA. So that's why we think that that's not as problematic as the reply might suggest. Our bottom line position is that under the step 1 analysis, you give the terms their correct legal meaning. And the correct legal meaning of a challenge to a sentence under 2255 would include the challenges he's making. And then when you consider the fact that the necessary byproduct would be to reduce the sentence by his own account by at least 25 years, it's covered. That's our position.
Thank you, counsel. Mr. Sandiford, has Mr. Tenney given you a few things to address?
Yes, he has. I'd like to start with the last point. I mean, I don't think we're in disagreement about what the law is. When you're determining the scope, you look to what the defendant reasonably would have understood. That is an objective test. It doesn't matter what Mr. Lumoli personally thought. But, no court has ever held that sentence means conviction in 2255. So the idea that anybody would reasonably understand that in the absence of any court authority whatsoever seems like a stretch to me. Even if this court were to hold in this case that Mr. Tenney is right about how the statute is interpreted, it's novel and it has not been anticipated in any other court. So I don't think that's part of how he would have reasonably understood, or what he would have reasonably understood sentence to mean. Judge Matheson, on your question about whether he could raise this after his sentence is done, yes, he'd still be in custody when he's on supervised release, but the 1-year statute of limitations would have long since run. So that would not be available to him. He has a year after Davis to raise this claim, and that's it. And then it's gone. So there isn't a way for him to wait and challenge his conviction until after his sentence is over. I'd also like to address briefly this idea that, well, what Mr. Lumoli really wants is a lower sentence, and that is undoubtedly true of pretty much anybody who challenges their conviction, I would think. But he's not entitled to a lower sentence. He's maybe not entitled to a lower sentence at all, but he's not even entitled to a resentencing because there was error in his sentence. He's entitled to a resentencing because he has 2 924Cs right now. On the second one, under the law at the time, he had a 25-year mandatory minimum. So if one of them drops out, his mandatory minimum on the remaining charge drops from 25 to 10 years. He's entitled to be resentenced based on that new mandatory minimum, not because there's anything wrong with the sentence he's serving, but because the other conviction has been vacated. which just, again, underscores the point that this is a conviction challenge. He's saying that his 924C conviction is void and needs to be vacated because it violates Davis. Unless the court has further questions, that's all I wanted to say.
Does the PAM decision help the defendant or help the government here?
I think it helps us in the sense that PAM recognizes that a conviction is not a sentence, but I don't think it fully disposes of Mr. Tenney's argument that, you know, if the conviction goes, the sentence has to go with it. Therefore, a conviction challenge is a challenge to the sentence. PAM was the reverse situation, and he's correct that it doesn't apply to that. We think that argument is wrong for all the reasons that we've already explained here in our briefs. But overall, I think PAM, you know, that argument aside, I think PAM is fully controlling.
Other questions? All right. Well, we appreciate both of your arguments this morning. Interesting case, well argued. And we'll consider the case now submitted and counsel are excused. The court will stand in recess. Thank you.
When am I supposed to call?